As part of the recent Financial Services Development Council Practitioner Speakers Series, hosted by the Open University of Hong Kong, Ms. Bonnie Chan, partner at David Polk & Wardwell and member of the FSDC Council, assesses the state of corporate governance in Hong Kong. She finds some bright spots, but also identifies serious gaps, especially in the protections offered to shareholders.
Good afternoon, everyone. I am Bonnie, and today we're going to take a look at corporate governance in Hong Kong as well as responsible investment. So first of all, if you take a look at the topic of my presentation, it sets a perpetual work in progress and a sobering look at corporate governance in Hong Kong. So this suggests to you that this will be a very critical presentation, and I want to actually tell you that corporate governance in Hong Kong in fact still requires a lot of work. All right, so first of all, we hear this phrase all the time, corporate governance. What is corporate governance and why it is important? First of all, right, it is a very fluid concept, right? Broadly speaking, when people talk about corporate governance, it is about the mechanism or the process by which corporates are controlled and directed, a very broad concept. But we do hear people say, well, you know, we encourage corporates to have good corporate governance. What's the current state in Hong Kong? Now, this is Carlson Tong, the chairman of the SFC, and this is his view of the situation of corporate governance generally in Hong Kong today. Many of the Hong Kong listed companies are mid-cap, privately owned, and family-run enterprises to whom corporate governance is something of a work in progress. And the culture of responsible corporate practice has yet to truly set in. So he is quite critical. He's saying that, well, it's still a lot of work to be done before we, Hong Kong, can claim to have good corporate governance. So let's begin with the basics. How is corporate governance actually regulated in Hong Kong? There are a few building blocks. First of all, if you take a look at the law, obviously we have the statutory regulator, the Securities and Futures Commission, and they administer the Securities and Futures Ordinance. And there, they are mostly focused on market misconduct. So they want to make sure that if you invest in a publicly listed company, you disclose the interest you hold in that company properly. They want to make sure that the issuer, these corporates, listed companies, they disclose inside information promptly to investors. And they also deal with things like insider dealing, issue of false and misleading announcement, etc. So they are responsible. The SFC, responsible for the SFO. Then there is the company's ordinance, right? When you have a company which is incorporated under the Hong Kong law, the company's ordinance provides for certain basic protection for the shareholders in these companies. And in a way, the listing rules in Hong Kong also equalize the treatment. So if you have, for example, a Cayman incorporated company listing in Hong Kong, the fact that they've chosen to list in Hong Kong, they are expected to therefore also perform to the same standard as companies which are incorporated in Hong Kong. So the responsible regulator or agency for that piece of law is the company's registry. So SFO, CO. What else? The listing rules, very, very important piece of regulation. Inside the listing rules, you will see a chapter called Corporate Governance Code, and there you will see a lot of very specific requirements about how companies listed in Hong Kong should organize their corporate governance. For example, how many independent non-executive directors should they have on the board? What kind of compulsory periodic disclosures they should make? What kind of board committees they need to have, etc. And of course, the listing rules also have a whole list of requirements governing compliance. Once you are a listed company in Hong Kong, you are supposed to do, you know, a whole slew of things like holding your general meetings, making announcements, etc. This part, it's enforced by the Hong Kong Stock Exchange. Okay, so, you know, we see different laws and regulations. And essentially, if you think about the buckets, right, what broadly do these rules and laws provide for? First of all, the broad category of directors. They want to make sure that directors are organized in a way where they're put in certain structure, they're given certain roles, they have certain meeting procedures, There are regulations about how they could be appointed or removed. And of course, you want to sort of specify what their key responsibilities are, how they're going to be remunerated, what compensation are you going to pay to directors. So that's sort of under that category. Second broad category is accountability and audit. Imagine if you have stock in HSBC, right? You want to make sure that you understand how they're doing financially, right? What's their performance, and how do you find that out? You can only find that out when they issue their financial results. And in Hong Kong, it's biannually, meaning that they have a 6 months interim results and a full year annual result. You also want to make sure that a company follows certain internal controls and risk management procedures, and very importantly, an audit committee. So, it's such a big company, they can claim to have all these systems and procedures, but how do you know if they're following it? That requires audit, an internal audit function, which basically will go through these health checks to make sure, in fact, they are practicing what they're preaching, right? They claim to be following this. Then there is delegation by the board. Now, a company as big as HSBC, again, for example, you can't expect the board to know every single thing which is happening in the company. They have a big board, but there's bound to be some delegation, right? So the board will delegate appropriately the management function to different groups, right? It could be the senior management team, it could be other committees, and you want to have an idea as to how that is being managed. The next one, communication with shareholders. They may be doing it right, but if you are the investor and you have no channel through which you can actually find out how the company is doing, it also will not be very conducive to good corporate governance. And the last one, company secretary, that's a very important function. Big listed companies or even small listed companies, you do want to make sure that someone is there, always available, accessible to manage the company from a secretarial perspective. So this is what the CG code, the Corporate Governance Code, within the listing rules, that's the focus. You may think, okay, Bonnie, so far so good, right? So you've told me that there are all these rules, the SFO, the CEO, the listing rules, the Corporate Governance Code. We must have pretty good corporate governance, right? Assuming that the listed companies follow them. Is that the case? Now, let's see what the findings are. So every year, the Hong Kong Stock Exchange do a review. They will review all the financial reports of the 1,900 listed companies in Hong Kong, and they'll issue a report card. So let's take a look at the 2011 one. It was very good. They said 99% of issuers comply with 41 out of 45 code provisions, and satisfactory explanations were provided for most of the deviation. 99%, this is distinction. This is very good report card. However, let's see what they said in 2016. We found a few cases where issuers did not disclose auditors' remuneration. There are still instances of insufficient disclosure in the nature and impact of significant events. And then we identify a few areas in which business reviews had room to improve. Disclosure, directors' emoluments were incomplete. So they were not as quick to congratulate themselves as 5 years ago. And this is good. You shouldn't be complacent. You should really take a look at what the problems are and reflect upon them and try to make improvements. Let's actually have a reality check. I promise you this is the critical presentation, and here comes the critical bits. What actually falls short? Now, first of all, in Hong Kong, there's no such thing as class action. In the United States, and you'll read about it all the time, if, say, there is a listed company and the directors did something terrible, right? They committed fraud or they embezzled money, right? Take money away from the company. What's going to happen? Shareholders sue them, right? They take them to the court and, they will be punished. Some people may remember Enron, for example, right? That's the case where they committed, significant fraud, and eventually some of the directors of that company was put to jail. And there could also be civil action, which would result in compensation being paid to investors. But in Hong Kong, there is no such thing as class action. So if you are a shareholder, you invested in this company, and you felt that the directors were breaching their duties, right? They were, either not paying, enough care to managing the business, or, worse still, they embezzled money. What are you going to do? In Hong Kong, you cannot just get together as a group of shareholders and initiate an action against these directors. The only machinery available in Hong Kong is something called a derivative action, but that's only available in very limited circumstances. And also, it's very expensive to sue. Lawyers, I'm a lawyer myself, but we're not cheap, right? So, unfortunately, because of this, it takes away a very useful weapon against bad behavior. Over the years, there have been a lot of talk about improving this, and in fact, 10 years ago, there is a Law Reform Commission initiative. They formed this class action subcommittee, and they were trying to figure out whether or not there's a way to introduce class action into Hong Kong. Now, after 10 years, they have made very small steps, and they said, okay, we can make some proposals for class action, but let's start with like consumer cases. In United States, for example, if there is a sort of some medication, right, which turn out to be bad, people can sue in a class action. Hong Kong is beginning towards that direction, but so far as corporate governance is concerned, still no class action. So that's first reality check. Second one, shareholders redress. In a similar vein, right, I told you just now it's very expensive. In a lot of jurisdictions where shareholders, right, if they really think that the company's directors have done something terrible, they want to sue, they can actually hire a lawyer on a contingency basis, right? So the lawyers would say, okay, I'll represent you, I will do the litigation for you, and I will share in the compensation on a success basis. So if I win, I share. If I don't win, you don't need to pay me a single dollar. In Hong Kong, that's not allowed. So contingency fee arrangement is not allowed. I'm a lawyer, I must charge you if you want my service. And there is also the loser pay system. That's even worse. What does that mean? That means if you go and sue a company and you lose the litigation, not only do you need to pay your own lawyers, you need to pay the legal cost of the other side. The party who you sued and now, has won the litigation. That's called the loser pay system. So just imagine, if you are the investor, even if you really think that someone was unfairly treating you, you don't want to sue because it's so expensive, and if you lose, you're going to be bankrupt. So this is another reason why in Hong Kong, right, shareholders' interests are just not very well protected. Now you may say, do we not have shareholders activist group? There is David Webb. He's supposed to be, the champion of good corporate governance. Yes, he's very active, very vocal. He's very critical of bad corporate behavior. However, he's just one of very, very few. And it takes a long time for people to actually be aware of, these initiatives. Unfortunately, that's not going to help much. Shareholders' empathy, right? A lot of times, investors don't really care. They buy the shares and they just want to flip very quickly, earn some money, and that's it, right? They're not going to attend the AGM and then raise their hand and ask very challenging questions to the management of the company. The regulators, what about the regulators? The SFC, the stock exchange, why are they not taking care of the small investors? They are, but I will tell you later that their weapons are actually very few. So we didn't really do well in class action or shareholders redress. How about relying on the independent non-executive directors, right, to take care of things? They are independent, right? So they should really be representatives of the minority shareholder interests. Now, first of all, what do the listing rules require? At least 3 INEDs on every single board of listed company, and out of which one has to have professional qualifications on an accounting or financial management expertise. INEDs must made up at least 1/3 of the board. So if you have a 10-member board, you need at least 4 INEDs. However, I can tell you in reality, first of all, it's very difficult to find good INEDs. There are not a lot available. And then the independence is a little questionable, because just imagine if you are, appointed by the controlling shareholder, right? He has the votes to vote you to become an INED. You may not want to really disagree with him too much, right? Otherwise, the next time around, he probably will not vote for you. So there is a bit of a disincentive to do something to rock the boat. Also, the last point, which is very important, you can't be sure that they would even turn up Now let's take a look at 2 annual reports I've found, and let's see how the INEDs perform. So this one, with 3 INEDs, out of 18 meetings that year, they attended none. So I don't know how you rely on these 3 people to watch out for your well-being. Another one, this one slightly better. They attended 3 meetings out of 17 in a year. So, even if they don't show up, chances are they will be reappointed, they will earn their remuneration as director, and that's it, right? You are the poor investor in this company, you really don't have a lot of channels which you can complain about this kind of behavior. Closely held listed company. I think this is another very prominent feature in Hong Kong. A lot of the listed companies are actually family-owned. The Hong Kong requirement is that you only need to issue 25% of your outstanding capital to the public. That's called a public float. It's quite common the case that in a Hong Kong listed company, you have the controlling shareholder holding as much as 60%, 70% of the company. And if they have such a big chunk of controlling stake,